5, 4, 3, 2, 1, start. IA number 11867 of 2021 is allowed stop. The appellant is permitted to change its name in the cause title from Messrs. Asoka Metal Decor Private Limited to AMD Industries Limited, and the IA is accordingly disposed of. Stop. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court of Judicature at Allahabad in Trade Tax Revision number 275 of 2004, by which the High Court has dismissed the said revision application preferred by the appellant herein and has confirmed the order passed by the learned Trade Tax Assessing Tribunal, Lucknow bench. Stop. Lucknow herein after referred to as tribunal, and the assessing officer holding that for the goods manufactured the appellant is not entitled to the exemption under section 4A of the UP Trade Tax Act herein after referred to as Act, the manufacturer original revisionist has preferred the present appeal. Stop. Stanza. The facts leading to the present appeal in nutshell are as under. Stop. The appellant herein established the unit for manufacture of spun line crown cork in the year 1986, used as one on the packing materials of the glass bottles. The appellant submitted an application on 24/5/2004 granting eligibility certificate under section 5A of the Act before the Divisional Law Committee for manufacture of double lip dry blend crown under the program of diversification. Stop. Stanza. On the basis of the joint sport inquiry consisting of 2 members committee, the appellant was granted the eligibility certificate under modernization instead of eligibility certificate under diversification scheme. Stop. At this stage, it is required to be noted that if the goods manufactured would have been considered as a new product under the diversification scheme, the appellant was entitled to the exemption under section 4A of the Act. Stop. The appellant was denied in exemption under section 4A of the Act. Stop. The appellant preferred an appeal under section 10 of the Act against the order dated 10/12/2003 passed under section 4A of the Act before the Trade Tax Tribunal, contending inter alia that the process of manufacture and the machineries used for both the products existing and the new are different. Stop. Stanza. It was also the case on behalf of the appellant that the existing old product cannot be manufactured on the new installed machine, and vice versa, the new product cannot be manufactured on the old machines. Stop. It was also the case on behalf of the appellant that one of the major raw materials for both the products are not the same, and that ultimate use of both the products are different. Stop. It was submitted that the term modernization only those units fall which by the modern technical produce the same goods, and the scheme of modernization do not apply on the units which produce different goods. Stop. Stanza. The appeal preferred by the appellant came to be dismissed. Stop. The second appeal before the tribunal also came to be dismissed. Stop. It was specifically held that the nature of goods being produced under the modern technology is not different than the goods produced by the unit earlier, as both the produced materials are used in packing of the bottles of cold drinks, and therefore as the goods manufactured are not different. Stop. Stanza. The appeal preferred by appellant came to be dismissed. Appellant, the order passed by the tribunal. Stop. The revision application before the High Court has been dismissed by the impugned judgment and order, and hence the personal present appeal. Stop. Sri Atul Yashwant Chitle, learned senior advocate appearing on behalf of the appellant, has submitted that the issue involved in the present appeal is with respect to the interpretation of explanation 5 to section 4A of the Act, which grants exemption from payment of trade tax to units which had undertaken diversification in their units on or after 31/3/1996. Stop. Stanza. It is submitted that the appellant is a manufacturer of crown corks used for sealing glass bottles. Stop. Initially, it was producing spun line crown corks. Stop. However, subsequently, it diversified the manufacturing activity to manufacture double lip dry blend crowns, for which it imported new plant and machinery and invested a fixed capital cost of rupees 4.5 crores. Stop. Stanza. It is submitted that the new product being manufactured by the appellant is an eco-friendly product using PVC granules as raw materials. Stop. The new product is different from the spun line crown corks manufactured earlier. Stop. Stanza. It is submitted that the new product is an entirely different product from what was manufactured earlier, and the use of the product was also different. Stop. It is submitted that the new product was entirely different product in commercial parlance. Stop. It is submitted that the mere fact that both the products are commonly known as corks would have no relevance. Stop. It is submitted that similarly the fact that both the products are used for sealing glass bottles would also not be a relevant criterion. Stop. The test which was to be applied is whether the goods were different from those manufactured earlier. Stop. It is submitted that the appellant was entitled to claim exemption from trade tax since it has undertaken diversification, and the goods, that is double lip dry blend crowns now being manufactured, are of a nature different from those manufactured earlier by the appellant, being a different commercial commodity. Stop. Over.